You're welcome to my channel. In this video we are going to be talking about lifting of the veil of incorporation in company law. Ever since the case of Solomon versus Salmon, the court of law continued to uphold the doctrine of corporate personality, whereby the company can own property separate from its members. It can do its own things separate from its members. It can sue, it can be sued, and the acts of the company are different from the acts of the members. But nevertheless, this doctrine has led to a lot of injustices. So sometimes the doctrine of corporate personality is ignored and attention is paid to the real cause of the problem. And that's what we call lifting of the veil of incorporation. We ignore the doctrine of corporate personality and pay attention to where the real problem is coming from. There are two legal techniques of lifting of the veil, and the first one is statutory lifting of the veil, then case law lifting of the veil. We are going to look at each one of them in details. Let's first look at statutory lifting of the veil. Lifting of the veil, here the shareholder is held responsible for the company's debts or other problems of the company, despite the aspect of limited liability. So, statutory lifting of the veil, we can lift the veil where the number of members is below the legal minimum. If a company carries on business for more than 6 months after its membership has fallen below the statutory minimum, and that is 2 members for private companies and 7 members for public companies, every member during the time the business is carried on after the 6 months, and who knows that the company is carrying on business with less than the required minimum membership, is individually liable for the company's debts incurred during that time. And this is according to Section 33 of the Companies Act. So when the operating business and the number of members is below the legal minimum, every member who knows about it will be held responsible for the company's debts, and that's what we call statutory lifting of the veil. First, where the number of members is below the legal minimum. Secondly, they can lift the veil where the company is not mentioned in the bill of exchange. An officer of a company is personally liable if he signs a bill of exchange, maybe a check on behalf of the company, without mentioning the company's name. Under Section 109, Part 4, the veil of incorporation is lifted by holding that officer that is liable. If you sign a check without mentioning the company, it means that you're personally liable for everything. Then they can lift the veil in case of holding and subsidiary companies. Where companies are in a relationship of holding and subsidiary companies, group accounts are usually presented by the holding company in the general meeting. So in this regard, the holding and subsidiary companies are regarded as one for accounting purposes, and the separate nature of the subsidiary company is ignored. And this is under Section 149 to 153. Then the veil of incorporation can be lifted where there is reckless and fraudulent trading. Under Section 327 of the Companies Act, it's provided that if, in the case of winding up, it appears that any business has been conducted recklessly or fraudulently, those responsible for such businesses may be held liable without considering the aspect of limited liability. The veil of incorporation may be lifted when they're doing taxation. Under the Income Tax Act, the veil of incorporation may be lifted to ascertain where the control and management of companies is exercised in order to determine whether it's a Ugandan company for income tax purposes. Income tax, they will have to deal with the shareholders themselves, and that's what we call lifting of the veil. And lastly, under statutory lifting of the veil, they can lift the veil in case of investigation into related companies. where an inspector has been appointed by the registrar to investigate the affairs of the company, he may think of dealing with the shareholders personally instead of dealing with the company itself. Yeah, and that was all about statutory lifting of the veil. We are going to look at lifting of the veil under case law. Let's look at lifting of the veil under case law. We said lifting the veil means that the shareholders of the company will be held responsible for the company's debts or other problems of the company despite the aspect of limited liability. Yeah, so lifting the veil under case law, we can lift the veil under case law where the company acts as an agent of the shareholders. Where the shareholders of the company use the company as an agent, they will be liable for the company's debts. Then, secondly, where there has been fraud or improper conduct. If the shareholders use the veil of incorporation as an excuse for them to do illegal things like fraud or illegality, they can be held responsible personally. Yeah. Then the veil of incorporation can also be lifted because of the public interest or policy. When the people want you to investigate people individually. Yeah, sometimes courts have disregarded the separate legal personality of the company and investigated the personal qualities of shareholders because there was overriding public interest to be served. It's what people want. And lastly, the veil of incorporation may be lifted when determining the residence of a company for tax purposes. Yeah, and that was all about lifting of the veil of incorporation. Thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video. We shall be talking about management of a company.